Today we're going to be discussing courtroom testimony. Topics to be covered will be preparing for court or administrative hearings, courtroom attire, some don'ts, testimony, tips on testifying, training, refreshing your memory, courtroom terminology, depositions, and administrative hearings. As we've talked about in other modules or training lessons, security officers wear several different hats with the jobs they perform. In this training lesson, you will learn about another hat that we must wear as professionals during security work. As a security professional, you may, in the performance of your duties, be required to testify in either civil court, criminal court, or at an administrative hearing of some type. Your testimony is the time for you to shine and show people the professional that you are. Being prepared and knowing what to do will make you feel more relaxed and present a professional appearance to the court and the other people attending the court hearing. By being relaxed, it will also make your testimony more believable in that you feel confident in your answers. This training lesson is designed to aid you in preparing yourself for the day that you're called to testify before the court or administrative hearing. How you look, what you say, and how you act will all be covered in this lesson to assist you in your preparation for court. Preparing for court or administrative hearings. Officers should always review their incident notes, copies of reports, and any other reports pertaining to the incident prior to going to court. You should review times, notifications made, and to whom, weather conditions, the location, who was there, or if there were any witnesses. These are just a few samples of the things you want to remember or refresh yourself with before you have to testify. Dress appropriately for court. Business attire is standard courtroom dress. What this means: men, a suit, a sport coat, or a nice clean shirt and tie with slacks. Ladies, slacks, blouse, and blazer. This professional look gives the appearance of confidence. Some don'ts. Do not wear loud ties or ties with pictures on them. Do not wear a lot of jewelry. Men, no earrings. Do not wear your uniform to these hearings or court. Do not wear shorts. Do not chew gum. Do not wear hats. Show up a little early to court. Get to court a little early to familiarize yourself with the courtroom. Where is the witness stand? Where will you sit? Where will the attorney sit, etc.? This enables you to look professional by knowing the layout of the courtroom and how to get to the witness stand without being told where it is. Also, when you go into the courtroom, tell the clerk or the bailiff that you're there and what case you're checking in on. They may ask you to wait in the hallway until you're called. While in the hall, behave professionally. You never know who's sizing you up. And this obviously influences the jurors. Testimony. When you're called into the courtroom, walk directly to the witness chair and wait for the clerk to swear you in. The clerk will ask you to raise your right hand to be sworn in. Once you're sworn in, they will tell you to have a seat in the witness stand. The judge or attorneys will ask you questions. Wait until they finish the question before you start to answer. Tips on testifying. Sit up straight and look at the questioning attorney. Be calm and polite to everyone. Tell the truth and don't exaggerate. Give complete answers. Speak slowly and loud enough so the people in the court can hear you. Be yourself and just say what happened. Always look at the person who's asking the questions. Do not shake your head to answer a question. Answer with a clear yes or no so that the court reporter can write it down. Listen to every question carefully before answering. Always allow a pause after the question to give the attorneys time to object to the question if they want to. Keep your hands on your lap if you can. If either attorney objects, do not answer the question until the judge says you can. Only answer the question asked. If they want more information, they will ask more questions. If you do not understand a question, say, "I don't understand." If you do not know the answer to a question, say, "I don't know." If they ask a question and you don't remember, say that you don't remember. It's not against the law to forget details. Only state details that you personally witnessed when you testify. Don't speculate. Avoid looking at your attorney when answering a question. This looks like you're asking for help. Avoid being combative or show an attitude towards the opposing attorney. Let the attorneys get as nasty as they want. They could be baiting you. Stay cool. If you make a mistake, admit it. Don't try to cover it up. No one is going to hold it against you that you made a mistake. Never memorize your testimony. Know your facts, but don't try to say things word for word. If the attorneys ask you whether you have spoken with anyone, you must mention your conversations with investigators, lawyers, or any person related to the case that you may have spoken with. During testimony, do not use police or security terms. Do not try to guess why you are being asked these questions. Just focus on giving truthful answers. Training. If you're testifying to an event that took place relating to your training in a specific area, you need to know the dates you received that training, who gave you the training, and what additional training you may have had in that area. You should have this information in your notebook. Anytime you receive training, you should always log the training in your notebook. Prior to going to court, you should talk with the Senior Vice President of Human Resources to discuss your testimony and training. Refreshing your memory. Should a situation arise wherein you forgot some information or testimony, you may need to refer to your notes on the witness stand. You may ask to refer to your notes to refresh your memory. If allowed, the judge or attorneys may ask to see your notes. Also, you cannot read your notes out loud. You are to refresh your memory only. In other words, look at your notes, refresh your memory, put your notes away, and resume your testimony stating, "I have refreshed my memory." Then continue your testimony. Courtroom terminology. Every security officer should familiarize themselves with the terminology used in the courtroom. Knowing these terms will prove quite useful if you're called to testify. Cross-examination. A challenge to your testimony by the opposing side. Generally, the cross-examination is limited to matters covered on direct examination and matters affecting the credibility of your testimony. Deposition. Oral testimony taken by the opposing attorney with a court reporter present to record the proceedings. The attorney representing the parties for whom you're testifying will also be present. Direct examination. As a witness in a court setting, direct examination will be the first questions you will receive from an attorney regarding the facts of the matter in which you have personal knowledge. Expert witness. A witness who has been qualified as an expert in court. The expert witness will be allowed, through their answers to questions, to assist the jury in understanding complicated or technical subjects not normally within the understanding of the average layperson. An example would be a brain surgeon who is testifying on the workings of the brain. Impeach. To accuse. To charge someone with a crime. To question a person's good character or testimony. Objection. A protest by one side with regard to the question being asked or the witness's answer. Perjury. A person's statement accepted as fact and truth, but is actually falsely stated to mislead the court or the person who is conducting the proceeding. Perjury is considered to be a willful act to mislead the court or body of jurisdiction. Subpoena. Summons to court. A legal order or summons requiring a person to appear in court where they will possibly testify. Testimony. Your statements or answers to questions presented by attorneys. To make a solemn declaration under oath for the purpose of establishing or proving some fact. Witness. A person who is called to testify in court as to what they have seen, heard, or otherwise observed. Depositions. We have mentioned depositions briefly in the terminology section, but let's look at it a little closer so that you will understand them. A deposition is taken prior to going to court in a civil case. This session is recorded and you are under oath. The deposition is usually conducted in the privacy of one of the attorney's offices. There is no judge present at this hearing. Attorneys for both sides and a court recorder are present at the deposition. When preparing for a deposition, you will likely review your testimony with the attorney representing the client. Be prepared for unexpected or irrelevant questions. Always pause before answering any questions to give your attorney time to object to a question that he may feel is irrelevant. If an objection is posed to a question, stop testifying immediately. Continue your testimony only after you are instructed to do so. If you do not understand a question, ask the attorney to repeat it. Administrative hearing. An administrative hearing is a formal review of an occurrence or event in which witnesses tell their story. The setting for this type of hearing is less formal than of a court hearing. The rules of evidence admissibility are more liberal. Administrative hearings are usually conducted by businesses, organizations, or government agencies, and include such topics as grievances or arbitration. Preparing for testimony at an administrative hearing is no different than preparing for any other type of testimony discussed. As with other hearings, prepare yourself by reviewing your notes and reports. When testifying in court, it is important that your testimony reflects only facts that are known to you in the case. In an administrative hearing, you do have the opportunity to tell your version of what happened. This differs from testimony given in a courtroom setting, which is comprised of brief, direct answers to questions posed by an attorney. Summary. Witnesses who testify in court are called to tell the truth and to uphold the rules and laws of the court. To testify in court, a person needs to know how to answer questions properly and how to prepare for the atmosphere of the courtroom. This training has been provided for you to assist you in the performance of your duties. Should you be required to testify in civil court, criminal court, or administrative hearing, you will be prepared. Your testimony is your opportunity to show your professionalism. This concludes our training module on courtroom testimony, and thank you for your time.